appeal in the matter of Process and Industrial Developments Ltd. and the Federal Republic of Nigeria.
Yes, Mr.
May it please your lordships, I appear for the Appellant Process and Industrial Developments, or P&ID. My learned friends, Mr. Howard, King's Counsel, and Mr. Ford represent the Respondent, the Federal Republic of Nigeria. This is a rolled-up hearing, as directed by Lord Justice Mayles in his order of the 31st of January. And the substantive question that it raises is one that has not previously been considered by this court, namely, when should the court exercise its power to order a payment of costs in a foreign currency? And as the court will have seen, by his order of the 21st of December last year, Mr. Justice Robin Knowles ordered P&ID to pay Nigeria's costs of the proceedings in sterling as opposed to Nigerian naira. Just for your lordship's reference, the order is at page 82 of the core bundle, and the relevant paragraph is paragraph 5 on page 84. Now, the effect of that decision is that Nigeria stands to receive potentially up to around £40 million worth of costs, which as of today is equivalent to 68 billion naira. That is vastly more than the amount of naira that Nigeria actually spent to pay its legal fees, which was around 23 billion naira. So if one looks at the position in naira terms, which I'll be submitting is the right way to look at it, the effect of the judge's order is to confer a windfall on Nigeria of the order of 45 billion naira, or about £26 million at today's exchange rate. So a very significant profit. We submit that the judge was wrong to make that order. It is actually difficult to understand from his judgment why he made that order, but in any event, we say that it's wrong as a matter of principle. It's also contrary to authority, which, though not binding on the judge, we say he should have followed as a matter of judicial comity. We will therefore be asking your lordships to confirm that earlier authority, to allow the appeal and to substitute for the judge's order an order that the costs be paid in naira. But before I turn to that question, if the court is content with this, I propose to start by addressing the question of whether the court has jurisdiction to grant permission to appeal, which is the first question that Lord Justice Mayles ordered would be determined at this hearing.
Yeah.
And the jurisdiction question arises, of course, because the underlying proceedings were brought under Section 68 of the Arbitration Act, and Section 68(4) provides that no appeal can be made to this court from a decision, quote, under this section, close quote, without the permission of the court below. My learned friends say that this provision means that the court has no jurisdiction to grant permission in this case. We say that's wrong, that there is jurisdiction on the proper construction of Section 68(4). We also say, if we needed, that even if that were not the case, this court would in any event be bound to set aside the judge's refusal of permission because it was unsupported by any reasons and is therefore unfair and not a valid decision for the purposes of Article 6 of the ECHR. So I will start with the question of construction and then turn to the unfairness aspect. So far as jurisdiction is concerned, my lords, our position is very straightforwardly that a decision to order costs to be paid in sterling is not a decision against which the right of appeal is excluded by Section 68(4). It's common ground that this is a question of construction. So could we first look at the Act itself, and then I'll address the recent case law where this provision has been considered. It's in the authorities bundle at page 723. There is a Section 68, and I appreciate that this is all well known to your lordship, but I can take it quickly. Section 68(1) provides that a party may challenge an award on the ground of a serious irregularity. It specifically notes, I'll come back to this point, but the right to challenge an award on this ground is subject to the bar in Section 73, where the relevant objection was or could have been raised during the arbitration. and the restrictions under section 70, 2 and 3. Section 68.2 then defines what is meant by a serious irregularity. Section 68.3 then sets out the powers of the court if it finds there is a serious irregularity. Essentially, it has a discretion whether to remit the award, set it aside, or declare it of no effect. In this case, of course, the awards were set aside. Then finally, section 68.4 says that the leave of the court is required for any appeal from a decision of the court under this section. While we're looking at the statute, could your Lordships turn over to page 725, or the opus operator turn to 725. There we see section 70, which contains supplementary provisions relating to challenges under sections 67, 68 and 69. Subsections 72 and 3 contain restrictions relating to exhausting other remedies and time limits. As we saw, those are expressly referred to in section 68. And then it lists certain other powers, including the power to order security and security for costs. And both of those provisions expressly state that a challenge may be dismissed if an order for security is not complied with. And then finally at page 727, we see section 73, which is also expressly referred to in section 68. And that, of course, provides that a party who knew or could have discovered the grounds for an objection during the arbitration cannot then raise that objection later. So that is the framework, so to speak, for a section 68 challenge. It is a self-contained series of provisions specifically and solely concerned with challenges to arbitration awards. Going back to section 68.4 then, what is meant by a decision under this section? Now, I should make clear that I'm not inviting the court to lay down an all-purpose test, an all-purpose definition of those words. I'm only concerned with the specific question as to whether this decision to award a party its costs in one currency rather than another is a decision under section 68 for these purposes. But some general observations can be made. As a starting point, the natural and obvious meaning of the words a decision under this section, I suggest, is a decision of a court to exercise or not to exercise a power conferred by that section. That's to say section 68. In other words, a decision to take or not to take one of the steps listed in section 68.3, or more simply, a decision to uphold or to dismiss a challenge based on a serious irregularity. That is the natural and obvious meaning, I suggest, of the words a decision under this section. Now, I accept the analysis doesn't quite stop there for reasons I'll come to, but it is nonetheless an important starting point. What the section does not say, and in my submission cannot properly be interpreted to mean, is a decision in proceedings brought under this section. That, in my submission, would be a much wider provision, but it's not what the section says. And as we'll see, it's not what the courts have said that the section means. If we take the example of a costs order, which is what this case is about, that would obviously be caught if the statute said decisions in proceedings under section 68 can't be appealed. But as a matter of ordinary language, it is not right to say that a costs order is a decision under section 68. Why not? Because the power to make the costs order doesn't arise under section 68. It arises, obviously, under section 51 of the Senior Courts Act and CPR 44 and the principles that have been developed by the courts in relation to the application of those provisions. The fact the order happens to have been made in proceedings brought under section 68 does not mean that the costs order has itself been made under section 68 as a matter of plain language. So that's the first stage of the analysis. On the face of the statute, the restriction applies to decisions under section 68, and in my submission, clearly and unambiguously, that does not include an order about costs which just happens to be made in proceedings brought under section 68. Now, one could almost leave the matter there, but for the trilogy of recent cases on this point, which we need to look at. that case law, and particularly the last two cases of NIOC and Diag Human, makes clear that the restriction is not quite so narrowly confined as that. In other words, it's not confined to decisions that are literally made in the exercise of powers under section 68.3. But those decisions do not support the conclusion that any decision that happens to have been made in proceedings under section 68 is subject to the section 68.4 bar. And in my submission, that couldn't sensibly be the law, because it isn't an available meaning of the words in section 68.4, but it's not what the cases say is the position. Could I take the cases in chronological order, starting with Manchester City, which is at page 406 of the authority?
Look up an index file. I only have page numbers. 28.
I'm grateful. I'm conscious that my Lord the Chancellor was a member of the court in this case, and my Lord Justice Snowden was a member of the court in one of the other cases. So
I was a member of the court, but the views that were expressed, I think, on this point were oversight, weren't they?
they were, but I'm going to come to them anyway. But I'm just it's by way of an apology for retreading what's obviously familiar ground.
Well, it wasn't. It's not that familiar. It's nearly 3 years ago. One tends to forget.
I'm obliged, well, I'll take it reasonably quickly. Manchester City was a challenge to an award under both 67 and Section 67 and Section 68.
Yeah.
The judge dismissed the challenge, and then there was a dispute about whether her judgment should be published. The judge decided in favour of publication, and the question for this court was whether a decision to publish or not publish a judgment given in proceedings under Section 67 and 68 was caught by the restrictions on appeals. And this court held that the bars did not apply. I'd just like to take up the judgment of my Lord the Chancellor, paragraph 31 on page 414. There, Your Lordship noted that Lord Panic, who was for the appellant Manchester City, submitted there were 3 reasons why the bars didn't apply. And in the spirit of standing on the shoulders of giants, I'll run through what those are, because I'm going to echo them in my submissions. First, as a matter of language, what's being referred to was a decision as to the substantive jurisdiction under Section 67, or I would add, by way of analogy, whether there was a serious irregularity under Section 68. And a decision to publish a judgment was not itself a decision under 67. That's the point I've been making up to now. Secondly, this conclusion was supported by the policy reason for the restrictions in these sections, which was to limit further appeals because they would lead to delay in the resolution of a dispute decided by arbitration. 33, Lord Panic submitted that to recognise that this court has jurisdiction in respect of the appeal against the publication judgment would not impede that policy objective. The appeal would not delay the ongoing arbitration process, which would continue to take place in private. That's also a correct submission, I would suggest, and it applies to this case as well. An appeal as to the currency of the costs order can have no possible impact on the arbitration, which finished long ago, or the status of the awards, which have been set aside.
Well, except it's the delay and expense of the arbitration proceedings, which a number of cases have said that's why these bars are there, because they are in quite a number of sections, and it's really to the extent to which any proceedings related to the arbitration are still extant. So if this court has jurisdiction, it can be said, well, there is delay and further delay and expense by virtue of the appeal being heard, and at least notionally, if we do say we've got jurisdiction, somebody may go to the Supreme Court.
Yes, I accept that, Manuel, and I'm going to deal with that in detail. But essentially, if one interprets the policy of the Act as being to avoid delay and expense in all arbitration-related cases, then, of course, denying appeals as often as possible promotes that objective. But first of all, I've got 2 submissions essentially on that. The first is that is a wide reading of the policy, which is not necessarily the right one. There is a distinction in my submission between delay and expense in proceedings relating to arbitration, which would be the maximalist approach, and delay and expense in resolving disputes which the parties have agreed to be decided in arbitration, and avoiding interference in arbitration. And there is a sensible distinction in the sense that some types of decision, and this is one, make no difference. Of course, by any hearing involves delay and expense in a sense, but they don't involve the delay in deciding anything which was supposed to have been decided by the arbitrators. The awards are completely unaffected, and it is a distinct and discrete issue.
You probably are going to have to sort of, as it were, address this submission on a number of different hypotheses, aren't you? Because you say in this case, your case, the awards were set aside. So you can say, well, the costs, any squabble about cost doesn't affect the situation the parties are in at the moment, I think. I think that's what you said a few minutes ago. If there was a challenge to an arbitral award which failed at first instance, you can understand why it would be said there shouldn't be an appeal against that refusal to set aside the arbitral award so that people could get on and enforce the arbitral award.
Yes.
Mm-hmm.
But that's a different situation.
Yes, a challenge to an arbitral award and a decision on that substantive challenge is plainly caught by Section 68.4.
Exactly. But I think it's said against you. One of the points I think that's potentially taken is that if you have a continuing squabble about costs, especially if they're very substantial, that could knock on to the actual enforcement of the arbitral award, for example.
Well, it could. It wouldn't do so directly. I mean, another example that's been made is case management, raised in some of the cases, case management decisions during proceedings under Section 68, and it's a similar position there. As I said, I'm not asking your lordships to lay down a blanket test. Logically, I would submit the position is different for costs and case management type decisions, because those are not decisions under Section 68.4 itself, Section 68 itself, nor are they decisions which have any potential impact on, at any rate, directly on the outcome of a Section 68 challenge, or would lead to the status of the award being put in question. So they are discrete matters.
Why do you bracket them together though? Why do you say costs and case management both fall to be dealt with the same?
I don't necessarily, my lord.
I misunderstood what you just
it's just that in some of the cases refer or speculate about what the position might be in relation to costs or case management orders. And what they have in common, as I say, is that in neither case are they made under Section 68. That's the important point. They're made under different powers that apply to all cases. And the second point is that they don't have any impact on the award, so there would be no question of attacking a decision under Section 68 by the back door, so to speak. And that's the concern, and we'll come on to this in a moment, in cases like NIOC and DIAC.
Yeah.
The problem with those cases is that if you allowed appeals in those cases, you could get round the restriction in 68.4 by the back door, and that's why it has to be interpreted as covering those cases. But we're not in that territory, because these types of decisions, certainly on costs, and I would say probably also in case management, at least in many cases, do not create an end run around the Section 68.4.
Well, they could do that, couldn't they? I mean, you could have a case where, let's say for the sake of argument, the judge had said that the order for costs that the judge had made had been influenced by his decision on the main issue in some way. For example, by way of an order for indemnity costs or something of that kind, then it could be said, couldn't it, that if this court has jurisdiction in relation to the costs, then that is, in a sense, trespassing on the reasoning in the main the main judgment for which this court doesn't have jurisdiction. I mean, it's one of the oddities. I mean, you may be right or wrong. I'm not expressing a view either way because I can see the argument both ways.
Well, I would submit not, although of course it's a hypothetical and it might depend on the details, but in principle, there might be comments, it might be necessary for the court to comment on the reasoning in the final judgment, but in terms of the decision, that would be unaffected and it would stand as a decision and not be, its status wouldn't be called into question.
Well, again, I mean, like Lord Justice Fraser, I mean, I do wonder whether we need to take a moment to separate what I'd call interlocutory or interim decisions made in the course of a challenge under Section 68 to an arbitral award, and those which follow on from the resolution of the Section 68 challenge. I mean, I wonder whether that's a more straightforward differentiation between those ones than bracketing together cost and case management.
Well, yes, I respectfully agree that is a relevant distinction. I would submit that both distinctions are valid and apply. If the slight oddity about basing a distinction solely on when the order is made is that one then distinguishes between interim costs orders along the way and a final costs order, which juridically are not very different from one another, and it might be said to be a surprising if they were treated in a different way. But yes, I mean
the policy. I mean, we're going to have to come to this, but if the policy is to let people have one shot at Section 68 challenges, unless the judge himself says you can go on appeal, you can see that there might be a difference in approach between something which happens during the course of the Section 68 proceedings, for want of a better expression, and something which follows on after, like publication costs. And I accept you don't like it because that blurs the jurisdictional distinction that you want us to draw. But it is an alternative way of looking at the section.
it is, yes. I make both points, and first of all, it's not within the language. My 3 points are essentially that they're not within the meaning of the words decision under this section, not within the substantive scope, if I can put it that way, of Section 68. So that's to say the provisions dealing with challenges to awards in sections 67 to 73. It's not within that architecture, as it were. So it's not indirectly a decision under Section 68. And also it's a final decision made after the end of the proceedings. And I say for any or all of those three reasons, it is not called. I was in the judgment in Manchester City and just looking at Lord Panic submissions, and I think that was it. Yes, at paragraph 34, Lord Panic referred to Muslim authorities. These are not directly relevant, so I don't need to go to those. But then at paragraph 39, my Lord the Chancellor said this, that citation of the case has provoked a debate as to where the line was to be drawn. Lord Justice Mayo has posited the example of a case management decision. As I said at the time, that would seem to be an example of something which is part of the process of reaching a decision under Section 68, so it would be called. Sir Geoffrey Ross suggested to Lord Panic that a consequential decision on a Section 68 application, for example, as to costs, would also be called. Now, I'll come back to those observations, but can we first read what the court's actual decision was in paragraph 40? Can I just invite your lordships to read paragraph 40, please? So the question as regards cost orders was expressly left open. And despite the suggestions made in the course of argument, there is, in fact, no relevant difference, I submit, between the order for publication of the judgment in Manchester City and the order that costs be paid in sterling in this case. And by contrast, there are at least 3 similarities. And these are the points that I've just made. First, the power to make the order didn't derive from Section 68 or indeed from the Arbitration Act at all. So it's difficult to say as a matter of plain language that the decision was made under Section 68. Then, in neither case was the decision capable of having any effect on anything decided in the arbitration. And that's not just a question of timing, it's a question of substance as well. The nature of the decision is separate from anything that was to be determined in the arbitration. And so there'll be no risk of an indirect attack on either the award or the judgment dismissing the challenge. And thirdly, the decisions were made in both cases at the end of the proceedings after the substantive decision. So in all those respects, the costs order in this case is similar to the order in Manchester City, but different from the orders in the other 2 cases, which I'm now coming to. First, NIOC, which is page 690, and it's tab 35.
So, I mean, just to be clear, you wouldn't endorse what the Master Rolls suggested to Lord Panic?
That a cost order was
Might be called.
was not called, or was
I
called.
mean, he's not here, so you can say what you like.
Yes.
I mean, but you wouldn't endorse that, would
I
you?
don't endorse that. No, I mean, I say that with respect, great respect, that it's wrong. I mean, it's.
What about a decision on cost that wasn't, as he put it, consequential, but was made in the course of a Section 68 challenge?
Well, I would say that's not caught either, because although my third reason wouldn't apply, the first 2 would apply. That a decision on cost is not a decision under Section 68. First point. Second point is not a decision which, by its nature, is capable of having any effect, or where an appeal would have any effect on the outcome of the challenge or the awards. And so it's not within the substantive scope of the regime for challenging awards. And in that respect, it's similar to
Well, you
the
said
decision to publish a
the decision
judgment.
to publish was not under Section 67, Section 68 in this case. So the order for costs is not under Section 68 at all, it's under Section 51 of the...
Correct. That's one point. And then the other point is it's not. It's also because we're coming on to 2 decisions under Section 73 and Section 70. So one might say, well, those also aren't under Section 68, but they're still called. The reason for that is that they are still part of the machinery or the architecture of determining a Section 68 challenge, and it would be almost absurd if they were not called, because you could then overturn the decision by a side wind and avoid the bar on appealing under Section 68 itself, and that obviously wouldn't be sensible. But costs and publication are a long way away from that. So if we go to NIOC, tab 35, page 690, this is the case under Section 73. The defendant said that the claimant had lost the right to make the challenge because it had failed to raise the objection in the arbitration. That failed, and the defendant sought to appeal. We can pick up the judgment of Lord Justice Mayles at page 704, paragraph 45. He notes there that there was already, in fact, binding authority on Section 73, that a decision to dismiss a challenge under Section 73 was called. So the appellant had to argue that the position was different, where the court had decided not to dismiss a challenge under Section 73, which is quite a difficult argument, one might think, as indeed it proved. But jumping ahead to page 708, paragraph 59, after reviewing some authorities, including Manchester City, Lord Justice Mayles says, although these authorities do not answer the question we have to decide, they provide at least some support for a number of points. First, the policy underlying the section is to avoid delay and expense, and he notes at 61 that there's also a policy of non-intervention by the court in the arbitral process. I'll come back to that. Secondly, there are statements which suggest that a decision which is part of the process of reaching a final decision is a decision under section 67 or 68. Now, I'll come back to that, but I think the phrase part of the process is one that needs to be treated with some caution. It can be a valid analysis, but one has to be clear about what's meant by part of the process and what isn't. It doesn't extend, in my submission, to all decisions that happen to be made in section 68 proceedings. And thirdly, there's no support for the view that only a decision finally disposing of a challenge can be a decision under 67 and 68, nor is any distinction drawn between a party that's lost the right to object and a decision that it has not done so. None of that is controversial. And then at 64, we see the actual decision in this case. It says this is a question of construction, it has to be approached having regard to the object of the Act. And then at 65, in my judgment, it is clear that section 673 is entirely ancillary to sections 67 and 68. It has no relevance or application independent of a challenge to an award under one or both of those sections. A decision whether a party has lost the right to challenge an award is undoubtedly part of the process for determining a challenge and is within the compass of those sections. It is a preliminary question, but not a question going to the court's jurisdiction, the answer to which determines whether the court needs to consider the merits of the challenge. Decision is a broad term, and the determination of a section 73 issue is naturally to be regarded as a decision under section 67 or 68 as a matter of language, whichever way it goes, and so on. So that's the decision, all very clear with respect and indeed inevitable. After all, as Lord Justice Mayles had pointed out earlier in the judgment, it's somewhat strange for section 73 to be the subject of a decision in its own right at all. It's normally dealt with as part and parcel of the section 68 process. It makes little sense normally for section 73 to be appealed independently. But then we come to paragraph 66, which I anticipate is what my friends will rely on. That goes on to say, moreover, it's in accordance with the policy of the Act, as consistently described in the case law, to interpret 67.4 and 68.4 as encompassing such a decision. Well, just pausing there, such a decision, as I read that, refers to a decision in relation to section 73, and it doesn't go wider than that. It certainly doesn't encompass decisions that are not part and parcel of the substantive analysis under section 68, like costs. It continues, it would be paradoxical to interpret those provisions to mean that only the first instance court can grant permission on the final decision to uphold or dismiss the challenge to an award, but that the Court of Appeal can give permission on preliminary or case management decisions when the first instance court has refused such permission. Now again, there's no difficulty with section 68.4 applying to preliminary decisions. That's explained in paragraph 65, where Lord Justice Mayles says that a decision on section 73 is a preliminary decision, a preliminary question, the answer to which determines whether the court needs to consider the merits. The reference to case management decisions, and only case management decisions, it could, on one view, be read as pointing towards a more expansive interpretation of section 68.4 than I have been pressing for. But I would respectfully make a number of points about that. First, whatever it means, it's clearly obiter, because a decision that a challenge is or is not barred by section 73 is not a case management decision. Secondly, there's no reason to read it as referring to all case management decisions that happen to be made in section 68 proceedings. It would be surprising if that was what Lord Justice Mayles had intended to say, when the whole of the discussion before that sentence is focused on section 73 and its relationship with section 67 and 68. So what it seems to be referring to, in my submission, is case management decisions that are analogous in some way to preliminary decisions under section 73. For example, a decision on providing security, which we'll see an example of in a moment. It's most unlikely that Lord Justice Mayles intended at a stroke to say that all case management decisions are caught by the restriction on section 73, in section 68.4. The court had been careful to leave that open in Manchester City. It wasn't necessary for the decision in NIOC, and there hadn't been any argument on it so far as one could tell. And thirdly, I accept, of course, that Section 68 has to be interpreted in light of its purpose and the purpose of the Act, but that only takes one so far. One can't use the purpose of the statute to justify an interpretation which the wording does not legitimately bear, and particularly given the importance attached to rights of appeal. Finally, and I've made this point already, I don't accept it would be paradoxical necessarily for case management decisions not to be subject to the restriction, but substantive decisions to be subject to it. And that's because the primary purpose of the restriction is to ensure that matters that are decided in arbitration or supposed to be decided in arbitration are not then subject to appeals, as opposed to ancillary decisions of the court, which have nothing to do with the matters that are being determined in the arbitration.
I understand the point about the preliminary question, as Lord Justice Knowles refers to it further up in paragraph 65. But when we're looking at case management decision, what's the jurisdictional basis for case management decisions in the Section 68 challenge? It's the CPR, isn't it?
Yes.
And it's whatever underpinning there is for the CPR in terms of statute.
Yes.
So you'd say, do you, that actually as a matter on looking at the way you were putting your 3 points, that none of those decisions as a matter of jurisdiction are under Section 68 at all?
Yes, I do.
Or indeed under the umbrella framework of Section 68, Section 70, Section 73?
I do say that, Ronald, yes. They are merely decisions that are made in cases of all kinds that happen to have been made in Section 68 proceedings. There's nothing specific to Section 68 or indeed to arbitration about them, and so that I would submit that they're not caught, although I don't necessarily need to go that far, as I'm not asking for a blanket definition. But yes.
I'm just testing the jurisdictional point you make.
Yes, all of the decisions which are being caught are either decisions under Section 68 itself, or one of the sections which expressly contains the restriction, or they are Section 73 and Section 70, both of which are, though not strictly speaking Section 68, they are part of the same self-contained set of provisions that could lead to, could have an impact on the decision under Section 68.
There's another reason, isn't there, to try and gently nudge you away from case management, if I may. Case management decisions are part of the court's intervention in the award or in the arbitral process, whereas a costs award or order of the nature in this case is the court's regulation of its own proceedings, isn't it?
Well, yes,
So they're completely different in character.
They're different in character, I certainly accept that, yes. I wouldn't necessarily accept that any case management decision is necessarily an interference in the arbitration, or an intervention in the arbitration, because the challenge proceedings are separate from the underlying arbitration, and a decision as to how the court manages that process would not necessarily amount to an intervention in the arbitral.
Well, it's part of the process whereby the court becomes involved in the private dispute resolution mechanism, which is the arbitration. Case management.
Yes, it can be characterised in that way, in a general sense. As it would depend on what type of decision one was actually considering, but yes. But I would still submit it's in terms of jurisdiction. The jurisdiction doesn't derive from the Arbitration Act, so there might be. I can see the policy point that I think Your Lordship is driving at, that would infringe the policy in a way that a consequential matter like costs might not. Of course, that doesn't follow that it's necessarily within the meaning of the words of the decision under this section. That would still be a wide strikingly wide interpretation of a decision under this section to treat a decision as to, for example, disclosure of documents or expert evidence as a decision under section 68. But so I wouldn't necessarily accept that this case management decisions of that kind were within the section. But in any event, I do agree with your Lordship's fundamental point that there's a distinction between that type of decision and a consequential matter which has nothing to do with the arbitration or the award.
It's not so much as consequential, it's the other matter is a costs order which is given under a completely different primary statute.
Yes.
Which applies to all court proceedings, irrespective of whether they're concerned with arbitration.
Yes, exactly.
That's the real point.
Yes.
And it expressly says all proceedings, and then in subsection 5 makes a saving for criminal cases and bankruptcy,
Yes.
not arbitration.
No, indeed. The last case I was going to go to is diacumen, which is at page 451. Tab 30. And this was an appeal.
Which, although it's in tab 30, it's actually later in
It's later because the NIOC has been reported, so it appears to has a later date. But this is the latest in the trilogy, and it's an appeal against a decision dismissing an application under section 70, subsection 7, for security for the award as a condition of bringing a challenge under section 67 and 68. And the court essentially regarded this as indistinguishable from the NIOC case. If we go to paragraph 32 and following, we can see that that's page 460, Lord Justice Mills quotes at length from NIOC, and the conclusion is at page 462, paragraph 36. He says that only the first instance court can grant permission. And then at 37, he accepts that the starting point as a matter of statutory interpretation is that in the absence of clear words or necessary implication, there should be no restriction on whatever right of appeal a party has under the general law. That's an important point that we mustn't lose sight of. This is it's an important right that is being cut down. But he goes on to say that, in my view, the position is clear. And he gives 3 reasons for that, none of which are applicable to this case, any more than they would have been applicable in the Manchester City case. First, he says that Iranian oil applies. That's to say, Section 70 is ancillary or supplementary to an application under Section 67 to 69 and has no application independent of those sections. That obviously isn't true, as we've been discussing, of the cost jurisdiction, which has nothing to do with Section 67 to 69, or indeed arbitration. Secondly, deciding whether to order security is part of the process of determining a challenge under Section 67, 68, or 69. And his lordship compares it in that regard to Section 73. Again, that's not true of a cost order. Of course, a cost order is part of the process in the sense that it's made in the Section 68 proceedings, but that isn't what's meant by part of the process here. Part of the process here means that a decision either way can change the outcome of the proceedings and thus the status of the award. It's part of the architecture or the critical pathway to the final decision. And that means that a successful appeal could potentially overturn the final decision by the back door, and plainly that's to be avoided. And thirdly, at 41, he says this view is confirmed by the structure of the Act, with Section 70 located in the group of sections which deal with the powers of the court in relation to an award, and by the policy considerations described in NIOC. And again, needless to say, the point about the structure of the Act doesn't apply to cost orders, which aren't made under the Act at all, and nor do the policy considerations compel any different result. So if we take stock at this point, my lords, we have a trilogy of cases, all addressing different types of decision, one on one side of the line on publication of judgments, which is not subject to the restriction, and 2 on the other side of the line under section 73 and section 70, which are subject to the restriction. And for the reasons I've already given, in terms of that dichotomy, we say unequivocally a Manchester City type of case, not a Diag type of case. The decision doesn't derive from section 68, it's not a decision under section 68 as a matter of language, it's not part of the process of deciding a section 68 challenge in the sense in which that is properly to be understood, it's not within the compass, to use another phrase, of section 68. The position is further reinforced in this case by the fact that we're talking about a final costs order made after the end of the substantive challenge. So it's not even possible to regard it as a part of the process in some broader sense, I would say. Although that concludes what I was going to say on jurisdiction. We submit for those reasons the court does have jurisdiction to grant permission to appeal. And so I was going to go on to the procedural question of unfairness. The second reason why section 68(4) doesn't preclude an appeal in this case is that the judge failed to give any reasons for his decision.
This doesn't arise if you're right on the first point.
Correct, my lord. We only need to be right on one or other of these 2 points, yes.
Well, I suppose it might arise in this sense. Well, no. Because the court either has jurisdiction to grant permission to appeal or it doesn't on your
Yes, there's a
This is dealing with a different point, isn't it?
there's a procedural quirk which actually doesn't make any practical difference, but I'll deal with it. If your lordships were against me on the first point,
Yes.
but with me on the second point,
Yes.
then it's common ground that your lordships cannot grant permission to appeal in that case. You are limited to setting aside the judge's refusal of permission. So you would set aside the refusal of permission, and it would then be remitted to.
I was going to say what we can't do is substitute our own decision.
Correct, my lord. But what you would do is
Have to remit it to the
you
judge.
remit that question. But in doing
Directions as to how he should decide it. Or?
possibly, well, my lord, the position is this: there's already a decision of Lord Justice Mayles saying, in his view, it meets the threshold for permission. Unless your lordships say otherwise in your judgment, then that in itself is a fairly strong steer. Of course, if your lordships agreed with me on the substantive points and provisionally allowed the appeal, then that would speak for itself. It was plainly a case that met the standard. So what your lordship would do would be hand down judgment in the usual way. The question of permission would then be remitted to the judge. If the judge granted permission second time around, then no difficulty. Your lordships just issue an order either allowing or dismissing the appeal, as the case may be. If, which seems very unlikely, but in the event that the judge refused permission again, your lordship would have to dismiss the appeal for lack of jurisdiction. But there it is. All you could do is decide the point and remit the question of permission to the judge. It's slightly odd, but that is the way it would have to work. We say in short that this is a case within Article 6 where the lack of reasons makes the decision fundamentally unfair. And it's common ground.
Judge, I'm sorry to interrupt you, Mr. Mullen.
Yes.
Did the judge give reasons for his refusal of permission on the substantive issue?
No, and I'm going to take you to what he said. Let's go there now.
Where is that?
So it's in the transcript.
Sorry, I think we may be at cross purposes.
Yes,
I don't think my lord meant the substantive issue on the currency of payment. He meant permission on the
substantive
substantive judgment.
Right. Yes, he did. So there was
because we were interested just to see what he did say.
Yes, absolutely. So
in refusing permission to appeal to this court in relation to his decision to set aside the award.
Yes, so that is in the core bundle at how is it, in fact? I'm not actually, I said that I'm not sure we do have it in the bundle.
Which I suspect is why you were asked the question.
Yes, well, what happened was there was a day's consequentials hearing, and the judge reserved judgment on the substantive question whether to grant permission to appeal on the main, against the main judgment. And a couple of weeks later, he handed down a written judgment on that, which is quite lengthy. And we'll supply a copy, of course, to your lordships as soon as we can. But on the other issues, he gave judgment there and then.
So just so I've got this right as well. So when the judge was addressed and reserved judgment on whether to grant permission to appeal against his decision setting aside the arbitral award, was he reminded of the fact that that would be an end of it if he refused permission?
Yes. Yes, and I think from memory, although it's probably the transcript, he said that given the importance of it, he would.
And was anything similar said to him in relation to the costs question that is now the subject of this appeal?
I don't believe it was. We, for our part, did not consider that there was a restriction on appeals. But I don't believe, in any event, I don't believe.
I phrased my question neutrally.
Yes. I don't believe it was. No. Now, the existence of the jurisdiction to set aside the refusal of permission for lack of reasons is common ground. And I accept, of course, it is an exceptional jurisdiction, but this is a stark and extreme case because the judge gave no reasons at all for his decision refusing permission. And that is about as clear a case of unfairness as one could have in the High Court, I would submit. I would just like to take your lordships to the CGU case, which is the origin of the...
Lord, sir, I'm just going to interrupt just to say we just are not proceeding on the wrong basis. At page 134 in the transcript, in the supplemental one,
Yeah.
Mr. Justice Robin Knowles at page 195, line 18, he dealt with the...
Sorry, just pause for a moment, because I'm just trying to catch up with you. Page...
So it's in tab 9 of the core bundle, I beg your pardon, it's just where from the transcript.
Sorry.
So that's where his lordship said he was going to reserve judgment on the substantive point, and he did in fact deliver a written judgment the following week. It's just not in the bundle. On the costs point, it's not right that his lordship wasn't alive to the section 68.4 point. If you go to page 135 of the bundle, page 135, pages 199 to 200 is where my learned friend made his submissions on the permission to appeal. And you'll see at the foot of the page, Mr. Justice Robin Knowles said, "I'll refuse you again. Thank you for putting it concisely. I refuse you to stay." And at the top of the next page, he said, "It's a matter for, I don't know if there's something to think about, whether section 68.4 affects the costs point for appeal purposes. But you can think about that and take the course you're minded to take. But on that one, no permission, no stay. Thanks very much." So the question of whether section 68.4 was applied was very much alive. The judge, I mean, we didn't have to make any submissions on it, but the judge himself raised it and just left it as a question that my learned friend would have to consider, and obviously we would have to consider.
I'm grateful for the clarification to my learned friend. What I take from that is that it was, contrary to what I said earlier, it was in everyone's mind that it might apply, but nobody had expressed anyway a settled view as to whether it did.
But you, just to be clear, I'm pretty sure I am clear, but it's always, you asked for permission to appeal on the award of costs in the currency.
Yes.
And you were refused.
Yes.
You asked for a stay on the interim payment. That was also refused.
Yes.
The reasons were given in the concise terms in the transcript, but there's also a separate type up of that sheet in the core bundle, I think it's called judgment number 4. And those are the only reasons. No written reasons were given on the form late.
Correct.
In fact, those two rulings, which you've got as ruling 3 and ruling 4, tabs 10 and 11 of the core bundle, had already been given, hadn't they, earlier in the day? If you look at the timing of them.
Yes, exactly.
This exchange was at 5 o'clock.
They're the rulings on substance as to why he didn't find in my learned friend's favour on the argument.
Yeah.
And the transcript is when you ask for permission to appeal.
Yes.
Yeah.
So this dealing the substance, as it were, the actual ruling is ruling 3 or ruling 4, but the permission to appeal is dealt with at the end of the day.
Yes.
Okay. All right. Then
And I'm going to go to both of those.
there wasn't no further reasons were given for refusing permission to appeal.
Correct.
Okay. Did, right, hang on, there's some- Yeah.
I was going to go to CGU, but I think I probably don't need to go there now because it's common ground that the jurisdiction exists, and we can look at authorities if we need to later. But fundamentally, I think it is common ground that a decision which is given without reason is contrary to the requirement of fairness and can therefore be set aside in principle.
But even though it was 5 o'clock at night, you could have asked the judge to give reasons, couldn't you? You could have said, well, that's all very well, just turning us down, but why have you done that?
We could. I'm going to come to that. Could I just look at the two decisions such as they are? I mean, the substantive the ruling on permission to appeal is that. It's page 135, internal page 199, where we were. See, at line 18, I made the application for permission to appeal, and the judge's decision, he says, attractively put, if I may say, and thank you for the concision, I'm going to decide now to refuse you permission to appeal on that point. And that's it. And one appreciates the politeness, of course, but the fact is there is a total absence of reasons. Now, I do accept, of course, it was an extemporary judgment at a hearing where the judge had various points to rule on. It wouldn't be realistic to expect lengthy reasons, but there is nevertheless an obligation to give some reasons, at least a reason at a minimum, and that did not happen. And if the respondent is right that this is a case within section 68(4), which is the only circumstance in which this matters, then it could even be said that there was a heightened duty to give reasons.
Well, that's interesting, isn't it? Because the judge himself identifies the section 68(4) points at page 201.
Yeah.
He obviously had the point in mind.
He did, but
Although he doesn't actually say, well, I don't think you've got any right, I don't think the Court of Appeal has any jurisdiction. But he obviously had the point in mind. And you would say, well, given that he had the point in mind, all the more reason for giving at least some reasons for his decision.
I do say that. I mean, we don't actually need to get into this because it's not my complaint is not about the adequacy of the reasons. There just are no reasons, and on any view that is insufficient. Now, it might be said, of course, that one of the things that might be said is what we could have asked, and I'll come to that in a moment. But another thing that might be said is, well, everyone knows the test for permission is a real prospect of success. So if the judge refused permission, he must have thought there was no real prospect of success, and that's obviously the reason. But that isn't good enough with respect, because first it's wrong as a matter of law, because there is a duty to give reasons. They can be brief, but there must be reasons. And in all of the cases that are in the bundle, North Range, CGU, Kyler Shipping, they're all cases where the court scrutinised the reasons with some care, actually, and considered whether they were sufficient.
Yeah.
It's a low standard, but it does have some content. In none of the cases where the court was prepared to assume that the judge knew what the test was, and so it didn't really matter what the reasons were. The residual jurisdiction just wouldn't exist if that was the case. But secondly, the argument is logically wrong as well. The whole point of the duty to give reasons is to ensure that the decision given is a true decision in the sense that the judge has applied his mind to the relevant test. If there are no reasons, there's just no way of knowing whether the judge applied the test and decided it the way he did for reasons that were genuine, albeit unstated, or whether it's just the product of a lack of intellectual engagement, as it's put in the cases, or chance or whimsy in Lord Justice Mustell's phrase. So that doesn't work. The slightly different argument, which I think is made against me, is that the reasons can somehow be inferred from the substantive ruling on the currency issue. So I'll turn to that, but I wouldn't rule out the possibility that that could be an answer in some cases. So if the judge, for example, had said in his main judgment that my submissions were completely unarguable and he had no hesitation in rejecting them, for example, then one could assume he thought that that had no prospect of success. But that isn't what happened here. And if we can look at the main judgment at page 149, I'll come back to the content of it in more detail when I get to the substantive currency issue. But we see that paragraphs 1 and 2 record the facts. That Nigeria paid legal fees in sterling, but did so by converting on the information available to the court naira into sterling.
So where are you now?
I'm sorry, I'm at page
150.
149 is where I have it, but maybe it's 150.
Yeah.
Yes.
This is ruling 3.
Yes, 150. Yeah.
Yeah. Time.
So it sets out the facts in 1 and 2, and then says, although a large sum turns on that, the search as ever is for the correct approach. No dispute as to jurisdiction and so on. The court's discretion as to cost is specifically dealt with in CPR 442. Now, it doesn't matter for the purposes of the point I'm on, but that's wrong as it happens. This case has got nothing to do with jurisdiction, with discretion, and I'll come back to that point. But then the critical paragraph is paragraph 4, where he says, I've had the advantage of argument from Mr. Milner, which presses for an approach that would treat costs in the same way as damages might be treated on indemnity granted by a contract. On one view of Cathay Pacific, the learned deputy judge found a point of comparison between the cost jurisdiction and discretion and the approach where there's an indemnity in a contract. I'm not able to accept that parallel as sound for present purposes. The word indemnity features in the phrase indemnity principle when one's dealing with costs. Its purpose there is to describe the objective of preventing a successful party recovering a sum in excess of their liability to their own solicitor. In the present case, if costs have been incurred in naira, then this court, in the exercise of its discretion, might have more that favoured the argument addressed by P&ID. But in the exercise of the court's discretion, the short and neatly expressed proposition from Mr. Ford from Nigeria prevails. Now, I'm going to explain in a moment why this is all wrong, but the simple point for present purposes is that there's no indication whatsoever that the judge applied his mind to the test for permission to appeal, which is, of course, whether an appeal would have a real prospect of success. And there's nothing which even implicitly meets that test. If anything, it suggests that if the judge had applied his mind to the real prospect test, he would have said there was a real prospect of success, because he refers to Cathay Pacific, he identifies a point of law which was decided, at least on one view of the case, and he says he disagrees with it. And he doesn't say that our position is clearly wrong or unarguable. So there's nothing in either of the two rulings from which one can infer that the judge engaged with the permission to appeal test intellectually and in a way that satisfies Article 6. In those circumstances, subject to 2 points, well, 1 point, because I've dealt with the setting aside point. Subject to 1 point, this is a plain case for exercising the jurisdiction to set aside the refusal of permission. The 1 point that remains is the point your Lordship put to me, that we could have asked for reasons. It's true, we could have asked for reasons, but there are 3 reasons why that should not count against us. First, it's actually not clear that the principle which one does see articulated in other contexts that a party should ask the judge for reasons or more reasons before appealing or seeking permission to appeal. It's not clear that that principle actually applies in this particular context. None of the cases where the residual jurisdiction has been discussed, CGU, Bunge and so on, contains any discussion of that point. Indeed, in Bunge at page 205 of the authorities, paragraph 13, Lord Justice Longmore says that simply an unreasoned decision can be set aside, and there's no suggestion there or anywhere that a party in an arbitration case like this has to go back to the judge and ask for more reasons.
Well, except that if the basis for the complaint, if I can put it that way, is there's been procedural unfairness, then it must be part of the or an important aspect of that is whether or not the party asked the judge to remedy the apparent unfairness by giving reasons. Now, obviously, in a case in which the judge is asked to give reasons for his refusal of permission and then says, no, I've said what I've said and that's it, well, that would be a very stark case indeed, wouldn't it? But you could have said to Mr. Justice Robin Knowles, well, please could you give us reasons for your refusal in case we find ourselves in a situation where you are, as it were, the end point. The fact that you didn't must be a relevant consideration. It may not be a complete answer, but
well, yes, if we were if it were the end point, then in a sense the reasons would be academic. But yes, I mean, the answer is we could ask. One can always ask, but it's not what the cases seem to require in this area. None of the cases says that a party has to go to the judge and ask for reasons, and it may be because that in a normal case where this arises, the Court of Appeal is interested in the substance of the matter, even if there's also a procedural point that's raised, and so it wants to understand what the reasons were. But in this specific context, the court is specifically not permitted to look at what the judge's reasons were. The only thing that matters is that he has given reasons, and so maybe that's why the courts haven't said that parties should have gone off to get reasons. But in my submission, there is no obligation to do that in this context. The second point, my lord, is that even if the principle did apply in the same way it applies in other areas of the law, it wouldn't be engaged in this case because the principle that you have to ask the judge for reasons has its limits, and we submit that we fall outside those limits. And to make good that point, can I just ask your lordships to turn to a case at page 676 of the authorities, it's a case called Re C. It's at about tab 34.
yeah.
It's a family case, but the facts are not important. We can start with the head note, which says, although the practice of seeking clarification of a judge's reasons for judgment is well established in family cases, it is important to ensure it's adopted carefully and only in appropriate circumstances. First, it must only be used for clarification, never to re-argue the case. Secondly, it's the responsibility of counsel and courts to be disciplined when making and responding to requests. Thirdly, and this is the key point, where the omissions or deficiencies in reasoning are on a scale that make it impossible to discern the basis for the judge's decision, or where in addition to omissions the analysis is perceived to be deficient in other respects, it will not be appropriate to seek clarification, but rather permission to appeal should be sought. And that is amplified in the judgment of Lord Justice Baker at page 686. At 30, he makes the point that we've seen in the head note. And then, in support of that, between B and C on page 687, he refers to his own earlier judgment in Re O, where he says there are cases where the deficiencies in the judge's reasoning are on a scale which cannot be fairly remedied by a request for clarification. As Lady Justice King said in Re I, it is neither necessary nor appropriate for this court to seek to identify any bright line or to provide guidelines as to the limit of the appropriate nature or extent of clarification. But where the omissions are on a scale that makes it impossible to discern the basis for the judge's decision, or where in addition to omissions the analysis and the judgment is perceived as being deficient in other respects, it will not be appropriate to seek clarification, but instead to apply for permission to appeal. And then this, in this case, the deficiencies are on a scale which cannot fairly be remedied by a request for clarification. We would not have been asking the recorder to clarify an ambiguity or omission in part of his reasoning, but to set out his reasoning in its entirety. For my part, I would not be confident we would be asking the recorder to set out an analysis which he had in fact carried out, but for some reason omitted to include in the judgment. Rather, where the absence of recorded analysis is on this scale, there's a danger we will be asking him to carry out an ex post facto rationalisation for a decision he's made without proper analysis. And this would be wrong in principle and unfair. And we submit, my lord, we are squarely in that territory. The decision to refuse permission was given without any reasons at all. It was given immediately after the application was made, with no pause for thought. And there's no indication anywhere that the judge engaged intellectually with the test for permission to appeal. So it is impossible to be confident that any reasons we had gone back to ask for would have been the real reasons why the decision was issued at the time when it was, as opposed to an ex post facto rationalisation.
Well, sorry, wait a minute, before we get into that sort of submission, can we actually just look at what the judge said at 136, the transcript, the bundle in the transcript? I mean, this is just before 5 o'clock, very late. I think Mr. Howard has left. I'm not quite clear what the event on the, or what, is it a religious festival? What is it? I don't know. 8th of December, the judge says, appreciate what day of the calendar it is. I can't quite.
I think that may have just meant Friday, but I'm not certain.
Friday. It's a Friday.
Well, yeah. Okay. Right. All right. I don't know. Anyway, but so it's all happening very late in the day, and at 136 at the top, the judge does raise this question about whether 68.4 affects the cost point for appeal purposes, and he says, but you can think about that and take the course you're minded to take. I mean, he's, as it were, saying over to you. I mean, if you know, if it, or over to both parties, if it potentially falls foul of section 68.4, or otherwise, if what I've done is not sufficient, you can ask me. I mean, what else would he have meant?
Well, what I understood him to be, my lord, is that we can either apply to the Court of Appeal if we think that the Court of Appeal has jurisdiction, or not if we don't think the Court of Appeal has jurisdiction. That's what I understood him to be saying.
Right. So I mean, it's not. I mean, obviously we can only look at the transcript, but it's not some sort of suggestion that you can come back, have a more considered view.
Well, I mean, there wouldn't have been. I don't know. I mean, presumably there weren't submissions, were there, about Manchester City or anything like that?
No.
No. So it must just be something the judge had in his mind.
Yes, it was in the judge's mind because he certainly had been reminded that on the substantive decision there would be no opportunity to seek a second application. So
Yes, of course he had.
it had arisen in a different context earlier in the hearing. So we submit that where there are no reasons, and we would be asking the judge to set out reasoning in his entirety, which wouldn't necessarily be the reasons that were actually the real reasons. The third reason, my third response to this point, Lord, is that even if both of the first 2 points are wrong and we should have got reasons, then that still would not prevent this court from considering the appeal on the basis of the judgment as it stands. And the authority for that is the decision of this court in Re A, which is the decision that my learned friends rely on for this part of their case. It's paragraph 18. It's tab 15, page 195, at page 198, paragraph 12, paragraph 18. I mean, the Lord Justice Mumby it's the responsibility of the advocate to raise it with the judge. But then at 18, he says, if nonetheless, as in the present case, neither of these things happens, what is this court to do? It can, of course, proceed to decide the application for permission to appeal or the appeal itself on the basis of the judgment as it stands. Alternatively, it can remit the decision to the trial judge. But so even if I'm wrong and we should have gone to the judge to ask for reasons, then that does not prevent this court from considering the application as it stands.
There's also a form, isn't there, as a first instance judge if you refuse permission to appeal.
Yes.
It has to be filled in with the name, nature of the hearing, that you've refused it, and there's a box, or you put it on.
N460.
There certainly is such a form. I confess I don't know whether it's customary to use it in arbitration cases where it's not known if there's going to be even the possibility of a further appeal. Or
But it's usually lodged by the solicitors because it's
Right.
part of the documents you have to lodge with the, because in your appellant's notice you have to say that you didn't get permission.
Yes.
Was such a form submitted to the judge? No.
So, my lords, were you not to agree with my primary argument that there is jurisdiction to grant permission to appeal, we would then submit that the court should set aside the judge's refusal to grant permission on that basis. My lords, the hearing is being transcribed. I don't know if your lordships are minded to have a break or not.
Yeah, are they switching over transcribers or not? Because if they're not, we'll break.
Transcribe
but,
shaking their head saying they're not.
I mean, I sometimes don't actually have a transcriber break, which I probably regard as far too hard and tough, but because it does, the trouble is one says 5 minutes and then it turns into 10 and you lose, or even 15. But okay, we'll have a break, but on that clock there.
Transcriber says actually she's
So are you okay to go on? I can't see you. You happy to go on? Okay, we'll go on. Fine, brilliant.
I'm grateful to the transcriber. Right, so I turn then in the second part of my submissions to the substance of the appeal on the assumption that the court accepts one or other or both of the submissions on the first two issues. And the question, as I said at the outset, is when a court should exercise its power, and it's common ground that it does have a power, to make a costs order in a currency other than sterling. Should it ask, assuming it's invited to, in what currency the receiving party's loss was most truly suffered and award costs in that currency? That's our case. Or should it only ever award costs in the currency in which the costs are billed, as seems to be the respondent's case, although it isn't entirely clear from their submissions to date what the principle actually is.
Well, one of the principal distinctions is you focus on loss and they focus on liability.
Yeah.
Exactly, my lord, yes, and I'm obviously going
Is
to
it indemnification against liability or compensation for loss?
exactly.
That's the real issue, isn't it?
Yes, that's right, and I'm going to come to that.
Yeah.
Just to clear one point out of the way first, at the risk of stating the obvious, whether or not there is a principle that you identify the currency that reflects the loss is a question of law. It's not a question of discretion. So the judge's judgment, such as it is, uses the word discretion 5 times in 5 paragraphs. That is misleading, perhaps also concerning, but in any event, the question at the heart of the appeal is a question of law which has a correct answer. Now, if we're right that the principle we contend for exists, so the court has to identify the currency that reflects the loss, it then has to decide what that currency is. That is not a matter of discretion either, that's a question of fact. But that's not a question that arises in this appeal, because there is no dispute that the loss was, as a matter of substance and reality, suffered in naira. The only question that your lordships therefore need to decide is whether there is a principle that requires the court to identify the currency in which the loss was suffered.
No.
The judge's approach, therefore, was wrong in as much as he seems to have treated the whole issue as a broad question of discretion, as many decisions on costs obviously are. But here there's one question of principle and one of fact, neither of which he addressed properly. As to the question of principle, our case, as I say, is that just as in the context of other kinds of judgments, the judgments for damages, judgments under indemnities and so on, the court should make its order in the currency which truly reflects the loss. And that may or may not be the currency in which the costs are actually incurred or paid. It's not in dispute that that is the principle for judgments other than costs. We say, in agreement with the deputy judge in Cathay Pacific, which I'm coming to, that there's no good reason to have a different approach in the context of costs orders. And that was the point that the judge expressly didn't accept, and we say he was wrong not to do so. So to develop that case, I propose first to take the court to Cathay Pacific to see what that decided, and then to show, to address the arguments to the contrary, chiefly, as my lord put to me, the suggested distinction between costs and damages, one being based on indemnity and the other being based on compensation for loss.
Yep.
So could we go first to Cathay Pacific at page 274, which is tab 22. The decision of Mr. Kimball QC, as he is of course a deputy judge, but he also happens to be the author of a textbook on foreign currency judgment, so he does have some experience in this field. This was his decision on a summary assessment of cost. The receiving party's solicitors had invoiced for their fees and been paid in euros, and the question arose as to whether it was possible to make a costs order in euros, and if so, whether the court should do so. So there's obviously a factual distinction between that case and this one, in that case the costs were invoiced and paid in foreign currency, whereas in this case they were invoiced and paid in sterling, but using a foreign currency to buy the sterling to pay them. But that isn't a relevant distinction in terms of the principles as the judge analysed them. Now, a lot of the judgment is taken up with discussion of the jurisdiction to make a costs order in foreign currency. We can skip over that because it's not in dispute that there is jurisdiction. And we can pick up the reasoning on page 283 at paragraph 43. The judge says, an order for payment of cost is a judgment like any other, referring to NICredit.
Sorry, do we get anything from 42?
I'm going to come to 42. Yes, 42 is discussing compensatory awards to compensate a party for currency movement. So if a party has paid its costs in one currency and then by the end of the proceedings there's been a movement so that it no longer gets back as much as it spent, then it may apply for a top-up payment to compensate it for that loss. Now, there is at least one case where that's happened. There's at least one case where that's been refused. As the judge says here at 42, compensatory awards of that kind are controversial. They raise issues of principle and so on. It is difficult to see actually on what jurisdictional basis there could be such a top-up payment, although, as I say, there are cases where it has happened. One of the attractions about the contention, the proposition I'm putting forward, is that if you simply look to the currency in which the loss has truly been suffered, then you don't get into this argument about top-up payments and whether there's a power to do that. It's just irrelevant because you just award the costs in the currency that was actually in which the loss was actually experienced. And one can, as a thought
But it's
experiment,
by saying truly been suffered that you're wrapping up the quite important point with something of a gloss, if I may say so. On the basis it was billed in sterling and paid in sterling, then in your case, the paying party suffered the loss ab initio in sterling, didn't they?
ab initio, yes, my lord, but that isn't, the inquiry doesn't stop there. That's the point. That
Your inquiry doesn't stop there, I accept that.
Well, certainly in the case of damages claims, so outside costs, the inquiry doesn't stop there, and that's the point that we'll come to it. And all I'm saying is that there's no reason to apply a different approach in relation to costs.
The argument against you is that the inquiry does stop there.
Well, exactly. But my point is there's no reason in principle why it should. That's the point.
Well, that's as made. Well, yes, that's what you say.
It is what I say.
The
It's what,
difficulty is you run the risk of a whole series of sort of mini trials or mini inquiries as to what currency was used to buy the currency in which the costs were actually paid.
yes, well,
That's what this,
absolutely. That's the other point that's made, and I'm going to deal with that.
What happens if it goes the other way?
Exactly.
The naira go the other way. What happens? That the liability of the other party is reduced. Is it pro tanto?
Well, it's with respect, a very interesting question. Where would we be if the swing had been the other way? Nigeria would then be saying, well, it's all very well giving us £40 million, but actually we spent the equivalent of £100 million, so we want some more. And that's what the claimant in Elkanet was saying, which is what the judges, and Mr. Justice Arnold agreed with that and ordered a top-up payment.
Well, he may have been wrong then.
Well, he may have been wrong, but the beauty of it is that if the principle is, as it is with damages, you look to the currency in which the loss is really felt, then none of that matters. That you spent naira, you get naira back, and we don't then need to argue about whether there's jurisdiction to make top-up payments or what happens if the loss goes the other way. It's one principle for all. In this case, it happens to be us, the paying party, which is saying we shouldn't have to pay them this much because it gives them a windfall. But it could just as easily be a claimant who's saying, I've had to come to England and fight this case, and because of currency movements that I have no control over, my currency is now worth much more than sterling, and I want some more money. And
It only provides a windfall in any event if it's converted back into naira.
exactly, my lord. Yes, that's true. But then that's why one talks about the currency in which the loss is truly felt. What that means is that's the right currency in which to assess whether there's been a windfall or not. Just going on, if I may, in the Cathay, as I was starting at 43, noting that an order for the payment of cost is a judgment like any other. And then,
What does that actually mean?
well, it means that there is no reason, as a starting point anyway, there's no reason to apply a different approach when determining what currency it should be made in. I mean, there's no doubt, it's not in dispute that an order for cost is a judgment. I mean, that's almost self-evident. So,
Okay, I mean, the real question at the moment, which I think we're going to get to, is when the court makes an order for costs, is it doing so on the basis of an indemnity against legal services, the cost of legal services provided, or is it aiming to compensate for loss suffered?
It's compensating for loss suffered as a result of having to pay legal costs. So
Well, you don't get that out of that first sentence.
no, but we'll get it from a later.
So that's not what you're referring us to that for.
No, I'm not saying that not all judgments are compensatory. I mean, of course, we have a judgment for a debt. The fact that it's a judgment doesn't mean it's compensatory, but it does mean that.
I sort of slightly wondered why, therefore, the judge made the point at all.
Well, indeed, I mean, it's an introductory point and no more than that, I think. But if we then go on, he notes the change in the law introduced by Miliangos and says that it's become completely routine for courts to give judgments in foreign currency, and they've done so in a wide variety of cases. And then he says this, that to the extent there's an overarching principle that's emerged, it's that a court ought to give judgment in the currency which most truly expresses the claimant's loss. This is the phrase originally used by Lord Denny in the Folias and approved in the House of Lords. Then he refers to the indemnity principle.
Right, but that, sorry, just to pick it up. He's talking there about an overarching principle that has emerged from claims for damages for breach of contract.
Yes. Yes.
Or claims in tort.
Yes.
And then he says, and indemnity claims.
Yes. Well, an indemnity, of course, strictly speaking, is a claim for damages for breach of contract. So it's not a juridically.
Is it?
Yeah.
I'm not sure that's right.
Well,
Claim for an indemnity is not the same as a claim for damages for breach of contract.
If you're suing on a contractual indemnity which has not been honoured, you might say that, but not every order that A indemnifies B is a claim for damages. It results from a claim in damages.
Because it might be as to things to occur in the future.
well, all I meant by it is that where there's an obligation to hold someone harmless from a loss, then that's often what's referred to as
Well,
an
a
indemnity.
claim,
So-
you're absolutely right that the claim for indemnity under an insurance policy is a claim for damages for breach of contract.
Yes, that's all I was.
That's the point. That's quite right, but it doesn't follow, as my lord says, it doesn't follow from that every indemnity.
No,
Every claim for an indemnity is a claim for damages for breach of contract.
I accept that one.
No.
But if we go on the judgment, he refers to the indemnity principle. He says it's been recognised since 1860 that costs are awards of a statutory indemnity. And he refers to the well-known authorities where it said that costs are given as an indemnity, not imposed as a punishment or given as a bonus. And that if the extent of the damnification can be found out, the extent to which costs ought to be allowed is also ascertained. And then at 48 he says this: given that a cost award is intended to be compensatory.
Sorry, wait a minute. 40. You skipped over 47.
Yes.
Are you going to come back to that? Because I do struggle with what's said in Brawley as reported there.
Well, I mean, I think that's just a restatement of Harold and Smith in more modern language, but let me pause on it because I would submit that's entirely correct, that an award of cost is intended to compensate a party for what they have had to spend on the litigation, to the extent that it is reasonable and proportionate. Of course, you don't get 100% of what you've spent.
The focus could be, again, this is probing this distinction between you. You said that award of costs is intended to compensate a party for what they've had to spend on the litigation, whereas what's focused on by Lord Justice Longmore, it could be said, is the liability which has been incurred.
My lord, yes. I mean, this is fundamental, and I'm going to, of course, spend time on it. But I wanted to see what the judge in this case says is the principle, and then to unpack
One
it.
focuses on the liability that was incurred to the lawyers. That's incurred in sterling.
But let me deal with this head on, because it's obviously what's troubling the court. Right? So we're discussing the difference between indemnity or between liability and loss. So what a party is liable to pay and what they actually pay. In most cases, there's no difference between those figures, and in the great majority of cases, a party is billed by a solicitor for a certain amount and he pays that amount, and it therefore doesn't matter whether one is talking about liability or actual payment. There are cases where a party can recover more than they've actually spent because they nevertheless have a liability for that amount. I want to make clear that this is true not just in relation to costs, but it's also true in relation to judgments for damages or for contractual indemnities or other sums. So this is not a point of distinction between costs and other judgments. To the contrary, it's a point of similarity. I mean, just take an ordinary claim for damages. It may be that the claimant recovers his loss from an insurer or from a benevolent third party, like a relative. that payment that he receives will, in many cases, not be taken into account as reducing the loss. Damages will be awarded on the basis of the liability that was incurred.
Well, that's because it's res intra res acta, and because of the application of the doctrine of subrogation.
Exactly. In insurance context, yes, but in other contexts,
And in other contexts as well.
well, that may or may not be the case, but in the case of, similarly, in the case of costs, there are cases, for example, the respondent refers to a case called Miller, where a criminal defendant's costs were paid by his employer. He was nevertheless held to be entitled to recover costs under the relevant statute because he had a liability to pay them, even though in fact he hadn't paid them. But it's not a very different system. In all these cases, there are reasons of policy, not always expressly stated, but there are reasons of policy that arise when a wrongdoer or a paying party is looking to profit at the expense of some innocent third party, whether it's the solicitor who wouldn't be able to enforce his bill, or a third party that's indemnified the claimant, or whatever. And for reasons of policy, essentially, the courts say you have a liability, and that is a sufficient basis to make the cost award. And in those exceptional cases, it does not matter that the claimant or the receiving party is not actually going to receive, or has not actually paid what he's liable to pay.
I mean, you say they're exceptional cases. I mean, it is increasingly the case, and is often the case, that a successful party who has a liability to their legal advisors may be able to discharge that liability, or it may have always assumed that that liability was going to be discharged in whole or in part by somebody else. I mean, it's never an inquiry as to whether the receiving party has actually paid out of his own pocket his lawyer's costs and thereby suffered loss. I mean, that's not the basis for a costs award. The costs award is on the basis, usually, isn't it, just that they have incurred a liability, and how they actually or intended to discharge it, whether through a benevolent relative crowdfunding campaign or otherwise, has never been allowed to stand in the way of the full recovery of the liability to the lawyers, has it?
No, it hasn't, my lord. But
so isn't the focus on liability to the lawyers, not loss to the receiving party?
Well, to that extent, yes, but only where there's a difference between liability and what's actually been expended. These are. It's not a principle which is unique to costs, and it is, you are still compensating a person for the costs that they have incurred in relation to the litigation or will incur, and it's just that you don't inquire, as the Lordship rightly says, don't inquire into whether they are actually paid, because it's a sufficient basis to award costs on the basis of a liability.
But you say you're still compensating a person for the costs they have incurred. Why isn't it more accurate to say in legal terms that you are requiring them to be indemnified for the liabilities that they have incurred?
Well, yes, I don't quibble with that formulation, but what I don't necessarily accept is that makes costs somehow fundamentally different from either damages or certainly other forms of indemnity. For a non-cost indemnity, like an indemnity under a contract, where one may be indemnifying for liabilities, but it doesn't follow that you only look to the liability and automatically award that amount. So certainly when it comes to currency, because the situation where the liability is in a different currency from what it has actually cost a party to discharge the liability is different. I mean, there's no valid analogy, would submit, between the case where the liability has been discharged in one currency using another currency, which is our case, and a case where the liability isn't going to be paid for some other reason, such as because it's been paid by a third party. There's no valid analogy there, and we know there's no valid analogy because the general law treats those cases very differently. Where you have an award of damages or a contractual indemnity, you do look to the currency in which the person has actually had to spend. You don't just say, well, there's a liability and therefore that's I'm going to award that amount. It's not a mechanistic process whereby the currency of the liability automatically translates into the currency of the order. Well, can I finish by?
So by that, back your last submission, do you mean routinely the court should look at the way in which the sterling liability has been satisfied in sterling by seeing the source of the sterling funds before it was sterling in a foreign currency, for any foreign litigant?
If it's asked to, then a party is entitled to make that application, yes. And if it's an important issue, in this case it's a £30 million issue. I mean, major trials are fought over less money than that, and so in an appropriate case it must be acceptable for a party to raise arguments of that kind. There may be many cases where, in fact almost all cases, where it's simply not proportionate to have inquiries and arguments over issues of that nature.
Well, it's either right or wrong, isn't it? I mean, it's not a question of proportionality. I mean, if you're right, then in every case, there should be an inquiry. Every case which involves a foreign litigant, there should be an inquiry as to whether the foreign litigant has used its currency or some other currency to pay its liability to its solicitor. I mean, most solicitors' bills, I mean, Cathay Pacific is relatively unusual that the bills were paid in euros. Most bills are still in sterling, I think I might say. But foreign litigants will have used all sorts of currencies to buy the sterling, and they may have done it at all sorts of different dates. I mean, we don't know. The Republic of Nigeria may hold dollar accounts, and they may have used dollar accounts to transfer into naira and then transfer into sterling. You know, where does it end? This
well, let me make this head on. There are a series of answers to this point with respect. First of all, the concern is overstated because we've had the rule with judgments for 50 years or more, and the principle operates perfectly satisfactorily. It's actually very rare for there to be a dispute about the currency of a judgment. That may be because it's only worth having the argument if, one, the sums are large, and two, there's been a substantial currency swing, and that was the position in the folias, which I was going to go to, and it's also the case here, but it's actually quite an unusual situation. Secondly, whether or not the rule leads to complexity in other cases, there's no complexity in this case, either in terms of identifying the right currency or in carrying out conversions.
So we say it's not complex, so I'm struggling with this. Cathay Pacific was a summary assessment, right?
Yes.
The judge in the instant case didn't make a summary assessment.
No.
So it was something that would go off to be determined on a detailed assessment. So how is the detailed assessment supposed to run on your argument? Is it that for every payment that was made throughout this litigation, every payment that was made in sterling at any time, the costs judge has to conduct an inquiry to understand how that sterling was obtained and the exchange rate at the date it was obtained and then the date it was paid, because they may very well not be the same. I mean, for example, Nigeria could have bought sterling in advance at a particular rate and then used that as a fund to pay bills from time to time. So on every cost assessment in a case such as this, there has to be whole sequence of inquiries on the detailed assessment? Is that the way it's supposed to work?
It's not as complicated as that. And of course, one can always think of potential points that people might raise, which might then have to be decided. And again,
As a matter of principle.
as a matter of principle, the way it works is this: that I mean, we are told, it's page 18 of the supplemental bundle. We are told that Nigeria has paid costs on a regular basis by exchanging naira for sterling to discharge the costs of liabilities. So the way it would work is that the assessment, it's a massive exercise, the assessment. It's been adjourned for months because of the scale of preparing the bill, which is going to be a vast spreadsheet with 80,000 entries or something on it. The cost judge will decide which of those entries to allow and how much, or what proportion. It's a straightforward matter. Nigeria knows when the invoices were all paid, of course. It's a straightforward matter to add a column to the spreadsheet that includes the naira exchange rate on the date when the invoices were paid. And that's the date.
But that may not be the date on which the naira was spent to obtain the sterling.
No, but one comes across these sorts of issues all the time, and cost judges even decide this sort of issue all the time, where there are currency conversions. Which date do I take to convert a currency? I mean, that is a fairly routine issue for a cost judge to decide. Is it the date of payment? Is it the date when the currency was acquired? And that's just a matter that has to be decided. But it's an issue of principle, really, that's not going to lead to a tremendous amount of complexity. I do come back to the point that this cost assessment is a £30 million cost assessment. It's a major piece of litigation. And so if there are points that have to be decided, even quite complex points, or points which require some evidence, it shouldn't be out of the question that should have to happen. And well, this is the point that Lord Wilberforce made in the Folios, where the same argument was made to him in the context of damages. If I could just show your lordships that, it's Authorities, page 22. Tab 2. The paragraph between F and H. We may come back to that because that's stating the. Well, let's just look at F and H because that states the principle which I say should be applied in relation to costs. This question can be solved by applying the normal principles which govern the assessment of damages in cases of tort. Principles of restitutio in integrum and that of the reasonably foreseeability of the damage sustained. It appears to me that a plaintiff who normally conducts his business through a particular currency and who, when other currencies are immediately involved, uses his own currency to obtain those currencies, can reasonably say that the loss he sustained is to be measured not by the immediate currencies in which the loss first emerges, but by the amount of his own currency, which in the normal course of operation he uses to obtain those currencies. This is the currency in which his loss is felt, and is the currency in which it is reasonably foreseeable he will have to spend. Now, there's a similar paragraph dealing with contract, but which is along the same lines. So that's what's happened in this case. And we said, although sterling was the immediate currency in which the costs were paid, that is not the currency in which the relevant loss is actually felt.
And if you're going to apply the principle of restitutio in integrum to any costs award, wouldn't every litigant be entitled to an order for costs in the exact sum of the costs that they've spent?
No, because what is the loss which is compensated by a costs award? It is the costs insofar as they're reasonable and proportionate and not cut down by any other
Well, that's not the principle of restitutio in integrum, is it?
Well, it's restitution of the costs, the reasonable cost that you've spent. Just as in damages, you don't get necessarily indemnified for everything that you spent. It's what any cost which could have been avoided, you don't get compensated for. And it's the same with costs. But the reason I went.
So there would be room for an inquiry as to whether the receiving party had mitigated their loss by making exchange rate conversions at the right or most opportune time, or at least avoided making it at the least opportune time. Is that right?
Not necessarily, my lord, no. I mean, one of the things that's said is that, well, if you import this rule, then you import all of the rules to do with damages, and so people will be claiming consequential losses, and it all gets out of hand. That's not necessarily.
It's a fair riposte to your point. This is a point of law, not a point of discretion.
Well, what is a point of law is that if the court's invited to, it should look to the currency in which the costs have been, the loss represented by the costs order has been sustained.
But how do you smooth off the rough edges, as without using just an element of discretion? And if you're using an element of discretion in relation to this, why is it a point of law?
Well, I'm not saying that there's no discretion at all. I mean, in many cases, the courts often exercise discretion in terms of deciding what is proportionate and what is not, particularly in the context of costs. And it very often happens that the courts make rough and ready, broad brush decisions or assessments that, because it isn't proportionate to have arguments over individual items on a cost bill. But there are no bright line rules. The only rule I'm arguing for is a rule which permits a party to invite the court to have regard to the currency in which the loss which it is compensating was actually sustained, and requires the court to do that, at least to that extent. I went to this just to see what Lord Wilberforce said about the objection of complexity, and at letter H he says there are some objections to this, but I think they can be answered. First, it said that to use the method of finding the loss in the plaintiff's currency would involve the court or arbitrators in complicated inquiries. I'm not convinced of this. The plaintiff has to prove his loss. He wishes to present his claim in his own currency. The burden is on him, and so on. The same answer at letter B can be given to the objection that some companies, particularly large multinational companies, maintain accounts and operate in several currencies. Here again, it's for the plaintiff to satisfy the court or arbitrators that the use of the particular currency was in the course of normal operations of that company and was reasonable. And of course, in that case, that's talking about a claimant wanting to prove an entitlement to loss in foreign currency. The same principle should apply to a defendant wanting to show that the loss was suffered in a different currency. And then finally at D, he says, finally it said that
how would that work? I mean, it's one thing, as he says, for somebody who wants to have payment in his own currency because he knows all the information. He can say, well, he can bring forward. That's not the case here. So what, you get disclosure of the...
Well, we can ask, yes. We say, how have you discharged your sterling liabilities? And
then what disclosure rolling back into the source of funding and the operations of the...
If necessary, yes. And that's
party.
where discretionary and considerations of proportionality undoubtedly have a part to play, because the court obviously has control over what disclosure, if any, it's prepared to allow in relation to a particular case. And if it's disproportionate for there to be those sorts of inquiries, then it simply won't happen. But then the final point is that this is the same point really, that uncertainty will take the place of certainty under the present rule. Undoubtedly the present rule produces certainty, but it's often simpler to produce an unjust rule than a just one. The question is whether in order to produce a just or juster rule, too high a price has to be paid in terms of certainty. I do not think so. And then he goes on, and he says, although the claimant's own currency will normally be the currency of the loss, there's no universal rule to that effect. And then at H, at the bottom of the page, he says, to say that this produces a measure of uncertainty may be true, but this is an uncertainty which arises in the nature of things from the variety of human experience. To resolve it is part of the normal process of adjudication. To attempt to confine this within a rigid formula would be likely to produce injustices, which the courts and arbitrators would have to put themselves to much trouble to avoid. As we say, by parity of reasoning, there should equally be no rigid formula that cost orders must be made in the currency in which the costs are billed, as opposed to the currency which the receiving party had to spend in order to pay them. And if that results in a degree of complexity in some cases, although, as I say, this isn't one of them, then that's the price that's worth paying for fairness. And the courts will always be able to control the scope of disputes in the normal way to ensure they don't become disproportionate to the sums in issue. As I said earlier, it's worth pausing just to imagine what would be the position if the Naira had gone the other way. Wouldn't Nigeria be content to accept a cost order in sterling? Or would they be saying, we need to be compensated for the extra 30 million that we've had to spend? The only mechanism for that otherwise is the concept of the top-up payment, which, as we've seen, is problematic and controversial in itself. This is a much more elegant solution. It does lead to, undoubtedly, a degree of uncertainty in some cases, but it has an elegant simplicity about it in the cases where there's been a large movement and one party says it's going to be undercompensated. You just cut through those issues about what date you should convert the currency on and how it should be taken into account, if not in this way. Now that's anticipated most of what I was going to say on the substance, but if I may, I would like to go to Cathay Pacific because there's going to be argument, I'm sure, about what it decides. So going back to the judgment, this is page 283. As we saw at 48, he states the principle in the folias, which is in which currency is it most appropriate to compensate the receiving party. And then at 49, he says this approach, that's to say the approach in the folias, has already been adopted in the context of contractual indemnities. In the Dione, a ship owner paid overtime to the stevedores in Buenos Aires. Under the terms of the charter party, the owners was entitled to a 50% contribution from the charterers, and so on. The claim in US dollars was upheld. Mr. Justice Lloyd held that for claims for an indemnity arising under a contract, the principle of the folias ought to apply. The court should identify the currency in which the loss is actually felt or borne. So there's no difficulty about applying this principle in the context of an indemnity. One shouldn't get hung up on the concept that indemnity is about liability, and so it's got nothing to do with loss, and so this inquiry can't arise. Whether one's talking about liability or actual payment, one can still, in the interest of doing justice, one can look at the currency in which the loss is felt or borne, even if one is given an indemnity. And that's what the judge says in 50. He says, in my judgment, there's no reason why the same approach as was taken in the Dione should not be taken in the context of a statutory indemnity for the award of costs. The fact that the source of the right to the indemnity in the one case is a contract and in the other statute makes no difference. In both cases, it's appropriate to inquire as to the currency which most surely reflects the loss which the claimant has suffered. Now, my learned friends say this is all opposite. I say it's ratio. It doesn't matter because it's not binding on this court either way, but it is fundamentally what the case decides.
You've got to be a bit careful about all this. It's all very well. I was just reminding myself about the deal. Because in the deal, which he's referring to here, Mr. Justice Lloyd expressly rejected the argument that we're now on, that because the counsel for the charterers, I think it must be, yeah, for the charterers, sought to distinguish the folius and the dispinera on the basis that they were claims in tort or for breach of contract, by saying, well, this was a claim for an indemnity under the charter party. But the judge said, no, actually on a true analysis, it's a claim for damages for breach of an implied term of the charter party, that the charterers would pay their 50% share. So that's how he reasoned it. That's page 579, page 33 of the bundle. In other words, that it was a claim, as a claim under an insurance policy, for damages for breach of contract. That's Chandra Sanaga, which is the case I failed to remember that I was struggling to remember a moment ago.
Well, my lord, yes.
But I mean, this is, but we're in different territory here.
Well, he does go on, with respect, he does go on to say, even if the claim were not a claim for damages for breach of an implied term, I would still regard the case as being covered by that authority, that's the Foley House. And it's true that Lord Wilberforce distinguished between damages and indemnity, but he says that there may be many variants of situations in which a loss arises immediately in the form of expenditure or indebtedness. So he treats expenditure and indebtedness as in the same phrase, but is ultimately felt in another. In my opinion, a decision in what currency the loss was borne or felt can be expressed as equivalent to a finding which currency sum appropriately or justly reflects the recoverable loss. So there is, I think, no meaningful distinction drawn in the Foley House between liability and actual expenditure. Now that, as I say, is fundamentally what Cathay Pacific decides. And the White Book, for what it's worth, treats that as a correct statement of the law. It says costs may be awarded in a foreign currency. Such an order may be made where payment most truly reflects the claimant's loss, such that it is the most appropriate means to compensate the receiving party for costs incurred. And that, I say, is a correct statement of the law. It's White Book, Volume 2, paragraph 9A-202. Now, the judge then went on to apply those principles to the case before him, which was very straightforward because the costs were billed and paid in euros. Lufthansa was a German company, and euros were self-evidently the appropriate currency. There doesn't seem to be any argument about that. But what the case does not decide, in fact it decides the opposite, is the fact that the currency in which the costs are billed or paid, whichever is said to be the important factor, is by definition, or even presumptively, the currency in which the loss is actually suffered. And the whole crux of the reasoning is that the court should apply the same approach as in the Foley House. And in the Foley House, the facts were not that dissimilar in that expenditure was incurred in French francs but paid by buying French francs using Brazilian currency, and damages were awarded in Brazilian currency because that's what it had cost the claimant to buy the francs in which it discharged its liability. And there's a series of cases on similar facts to those with the same outcome that we refer to in paragraph 23 of our skeleton. There's that case. There's also a case called the Texo Melbourne, where, again, similarly to this case, a Ghanaian claimant bought or had to buy cargo in dollars, but because it would have bought it using Ghanaian currency, damages were awarded in Ghanaian currency, even though that had lost most of its value by the date of judgment.
Yeah. Can I gnaw away at this bone in a different way?
Yes.
We've been looking here at cases where the issue is because of a breach of contract or a tort or a failure to comply with a contractual indemnity, somebody has sued for loss. And so, in a sense, one is ordinarily looking to understand what losses the third party actually suffered, or in what currency they have actually suffered the loss. When the court makes an order for the payment of costs, the one thing I am clear about is it seems to be that order is given by the law as an indemnity. So the court is really then spelling out an obligation in the future to indemnify, or it's imposing an obligation to indemnify. Why do you equate the two? One is compensating somebody for loss that's been suffered in the past, where inquiry is obviously mandated or would seem to be mandated. But where the court makes an order for costs to be paid, isn't the court just simply saying you paying party must indemnify the receiving party against their liability? I do struggle a little bit, I confess, with Mr. Kimball's compression of those two things in that very short series of paragraphs between 46 and 50. Because I'm not sure he preserves any distinction between, on the one hand, compensation for loss suffered by reason of breach, say, of a contractual indemnity, but on the other hand, what the court is doing when the court is imposing something by way of a costs order.
Yeah.
And if I may just add to help, part of his difficulty, I think, in those paragraphs which my Lord Justice Snowden has mentioned, is that he takes out of context in 47 the sentence of Lord Justice Longmore, who proceeds in Brawley by analysing the different ways that indemnity costs have been described as either compensatory or penal. And he says, well, there's not really any difference between those two, and that's when he then goes on and expresses that sentence that my Lord Justice Snowden drew to your attention 20 minutes ago.
I'm grateful, my lord. Let me try and deal with this. There really is no relevant difference between indemnities and an award of damages. And this is the point that Mr. Kimball makes, and he's entirely right, I suppose, in that. When there isn't fundamentally a rigid distinction between them at all, and when the court makes an award of damages, it can perfectly well award damages for a loss that is going to be suffered, or an indemnity that is going to be incurred or has been incurred but not yet paid. It's an assessment of loss in a broad sense. Equally, when the court awards an indemnity in respect of costs, it is compensating a party for a liability that may have been paid already or may have yet to be paid. In exceptional cases, it may not be paid. But
with respect to you've just done what we asked you to sort of unpick. You used the expression compensating for a liability. That begs the question, is the court saying, when I am making a cost order, I am in effect ordering compensation? Or is the court saying, I am saying to you, paying party, you must indemnify the receiving party against that liability which they have incurred?
I don't accept there's any meaningful distinction between those processes, my lord, with respect. It simply doesn't matter. In most cases, they will be the same. In some cases, the court still regards it as appropriate to award an indemnity, to make a costs order, because there is a liability, and it doesn't inquire into whether it's actually going to be paid or who it's going to be paid by. In the cases where this has arisen, there are always cases where there are clearly policy reasons in play which make it appropriate, in the view of the court, to award costs, notwithstanding the fact that there may be collateral arrangements that mean that the costs are not in fact paid by the receiving party. But that doesn't mean that costs are somehow fundamentally different from other judgments, or that indemnities are fundamentally different from damages. It's simply not a relevant distinction. Let me just make a series of short propositions that I hope will reinforce this. First, the purpose of a costs order, I do maintain this, is that it is compensatory. It is supposed to compensate the receiving party for what it has had to spend on the litigation. I'm deliberately skating over any distinction there between liability to pay, actual payment, loss, indemnity. But in a broad sense, a costs order is to compensate a party for what it has to spend on the litigation within the constraints of reasonableness and proportionality. And that much isn't in dispute, I think. It's a form of statutory indemnity in that sense. Secondly, it is because costs are essentially compensatory that the indemnity principle applies to them. There are odd cases where liabilities are incurred but not paid, but fundamentally the essence of the indemnity principle is that costs should compensate a party for the actual loss and not more than that. And as we saw in Harold and Smith, the old case that's quoted in all the other cases, that costs are not imposed as a punishment, nor given as a bonus. They are supposed to correspond to, quote, the extent of the damnification. So they are supposed to compensate for loss, even if in some rare cases the loss, for reasons that are irrelevant, is not in fact sustained, or is reduced. Thirdly, the principle that costs should compensate for loss suffered and no more than that is entirely consistent with the approach to compensation and indemnities under the general law. The indemnity principle is not some exotic concept that's specific to costs jurisdiction. It's the same essentially compensatory principle that applies in relation to awards of damages and indemnities generally. So the fact that courts apply the indemnity principle when awarding costs is not a point of distinction between costs and other judgments. It's a point of similarity. And that's important because to the extent one can discern what the judge's reasoning was at all, he seems to have thought that the indemnity principle as it applies to costs is somehow different from indemnities that are given in other contexts, as if it was just a coincidence. It's called the indemnity principle. But that isn't right. The indemnity principle that applies to costs is the same compensatory principle that applies in the law generally, and the extent of the indemnity should correspond as far as possible to the loss suffered. Fourth point is that despite the fundamentally compensatory nature of the principle, it does happen that parties sometimes recover more than they've actually had to pay or will have to pay. But as I said, that applies both to damages and to costs awards, where a third party has paid the costs or the claimant's been indemnified by a third party. Those are special cases where, for reasons of policy, the arrangements or the circumstances which reduced the loss are treated as irrelevant or collateral, and the claimant is still allowed to recover because he's incurred a liability. But that's
so you say, I mean, those are the ones I was actually particularly interested in, because you say that, I think your submission, in fact, it's run through all of the points, in truth. You're saying that those are special cases or rare cases or abnormal cases, and there's some policy which we need to look at. Because in the modern era, it is quite often the case that litigation is funded by third parties. And I mean, take a very simple case of somebody who has no money at all to pursue their claim, but they have a number of family members or other people who are prepared to put up the money to pay the lawyers. There's never going to be any question that the claimant himself, or the defendant, the party, has any money to spend. You were using the word spent, and I understand why you were doing it, and I thank you for that. But he's never going to be spending any money because he hasn't got any. But there's no doubt at all in those circumstances, because he is the claimant or defendant, and he is the party liable to the lawyers, if successful, he can recover costs. And yet I don't understand that to be a special case or a rare case or anything else. It's because the law focuses on indemnification against liability rather than loss. So you're going to have to make good, I think, that situation is a, quote, special or rare, or identify the policy that you say is abnormal and wouldn't apply in this case.
Well, yes, Madam, thank you. In a sense, it doesn't matter how special or how rare it is, but there are such cases, and I don't think it's possible to encapsulate in a single sentence a policy that unifies all of the cases and the reasons why parties are. That situation is said not to breach the indemnity principle. But undoubtedly there are reasons why, to take litigation funding, for example, why it should not be regarded as breaching the indemnity principle for a claimant to recover costs. There are obvious policy reasons in play there, just as there are in a case where a person benevolently receives a sum of money from a relative. But the point I'm making is that that isn't a point of distinction really from an award of damages. If a claimant is injured but is then gifted a sum of money by a relative, then that may very well be treated as a collateral matter which doesn't reduce the loss. And none of that answers the fundamental question we're concerned with, which is a situation where the losses or expenses are paid in one currency using another currency. Is that a case where one can just simply look at the indemnity and look at the liability and say, well, that should be indemnified, and that's the end of the story? And in my submission, no, because it doesn't. It is not analogous to any of the cases where the courts have done that in other contexts, where it's said that there'd be a breach of the indemnity principle, and the court says no because there's a liability. It's not analogous to any of those cases. We can see that from the general law. But my lord, even if that was wrong, and it ultimately wouldn't help, because all it would tell you is that awarding cost in sterling does not breach the indemnity principle. But that isn't a complete answer to the case, because I don't need to show that awarding costs in sterling breaches the indemnity principle in a strict sense. So the indemnity principle provides a ceiling above which the court cannot award more costs. But your lordship could perfectly coherently and correctly decide that although strictly speaking awarding costs in sterling did not breach the indemnity principle, because the indemnity principle in its strict sense only looks to the liability, nevertheless it's still appropriate to award to award costs in the currency with which they were paid, rather than the currency in which they were immediately incurred, because that reflects the actual cost to Nigeria of the litigation, and that is overall a much fairer result. So it's not my case that the judge was bound to award a cost in naira to prevent a breach of the indemnity principle. I do, of course, say it breaches at the very least the purpose and spirit of the rule, but whether it technically breaches the indemnity principle doesn't matter. The point is that there's no need to adopt a rule that costs must be awarded in the currency in which they are billed. And that could itself lead to disputes around why costs were billed in a certain currency, whether they needed to be billed in a certain currency, and it would not be consistent with the essential nature and purpose of the indemnity principle to adopt a blanket rule the other way. The only other point is the complexity point, which I've largely dealt with. As I say, it's overstated because it doesn't cause any difficulty with judgments in the real world. This is, on any view, a large piece of litigation which does, where it's no answer to say that the application of our principle would lead to complexity. The law will, of course, point that costs are there to resolve disputes, and if there are disputes, then that is the price worth paying for a rule that is geared at achieving fair results. And of course, the point I made that our position avoids complexity in the sense that it avoids arguments about whether one should get top-up payments and that sort of thing. We submit that this is a simple, elegant approach. It's the same approach that's adopted in other judgments and other types of indemnity. There is no reason in principle to apply a different rule in relation to costs, just because the touchstone in many contexts in relation to costs is said to be the existence of a liability. That is not an answer in this case, because there's no principled reason for applying, for simply looking to the liability and the currency of the liability and no further in relation to costs. Therefore, we invite the court to grant permission to appeal, having decided it has jurisdiction to do so, and to allow the appeal and to substitute for the judge's order an order that the costs should be paid in naira. Unless your lordships have any further questions, that's my submission.
Thank you very much, Mr. Yes, Mr. Howard.
My Lords, as you know, following the 8-week trial in the Commercial Court, which Nigeria was the successful party in its application under Section 68, Mr. Justice Knowles ordered that P&ID should pay FRNN Nigeria's costs in the currency in which they had been incurred and paid. Stress that, namely pounds sterling. Now, the rolled up hearing concerns two issues. First, the threshold question of jurisdiction, whether an order for costs under a successful or upon a successful application under Section 68 is to be regarded as a decision under Section 68 for the purposes of Section 68(4), such that only the first instance judge can give permission. And my Lords, for reasons which are not merely forensic, although none the worse for that, it's important just to bear in mind the following. It will become apparent why I say this. Mr. Justice Knowles found that the arbitration in this award, which by the time we were before the court was worth $11 billion, had been obtained by fraud. Indeed, the upshot of all of this is that P&ID and their backers are simply brazen fraudsters who in essence tried to use the arbitration process to rob Nigeria and its people of no less than $11 billion. Now, P&ID correctly recognises it cannot appeal those findings because Mr. Justice Knowles rightly refused it permission to appeal, and that's the end of the matter so far as the setting aside is concerned. Now, turning back to the issue, we submit that the position is clear and that a decision on costs at the conclusion of a set-aside is a decision under Section 68 for the purposes of subsection 4. And it would be, I suggest, very odd and surprising if it were not. And the reason I say it would be very surprising and odd, it would mean that a costs appeal would have the potential to trespass on matters determined by the judge as part of the set-aside, but where the Court of Appeal has no jurisdiction to deal with the substance of such matters. Now, I'll develop that. Perhaps
that was the point that I did put to Mr. Milner.
You did. And let me actually, I think I should sort of deal with this head on at this stage and just explain how that would apply or could have applied on the facts of our case. So, I don't know whether your lordships have read the judgment. There's no particular reason you should have done. But his lordship found that three particular individuals, amongst others, but three particular individuals, Mr. Cahill, who had been part of P&ID, Mr. Andrew, a solicitor, and a Mr. Burke of King's Counsel, a criminal silk, had all behaved dishonestly and given dishonest evidence. Now, as it happens, for reasons that we don't need to go into, his lordship decided not to award indemnity costs. I think he should have done, but that's beside the point. But he didn't. Let's assume a different scenario, and he had. And P&ID had then sought to come along on the costs appeal and to say he shouldn't have awarded indemnity costs because he shouldn't have made these findings that we acted dishonestly and that these witnesses gave dishonest evidence.
Well,
No.
Except presumably the answer to that is you have to take the main judgment, which is not subject to appeal, as you find it, and
Well,
submissions have to be made on that basis. You can't go behind the main judgment. Make your submissions on the costs on that basis.
Well, the difficulty, you see that, my lord, if one just thinks about it, the difficulty with the P&ID approach is, yes, I can't appeal the setting aside. I can't appeal the decision to refuse to set it aside. But for instance, a decision about whether witnesses were lying, that might be just something in the course of the judgment the judge has decided. It may be relevant to the set aside. But in my submission, if you agree with P&ID's position, P&ID or a party in their position would be entitled to come along and say, well, I can't challenge the set aside because I haven't been given permission. But the basis on which the judge has made these findings is not appropriate. Indeed, Mr. Andrew.
That would be a collateral challenge,
Well,
which you shouldn't be permitted to do.
well,
No.
shouldn't be permitted, absolutely. But in my submission, if you agree with P&ID's position, then the court, as a matter of discretion, of course, could say, I'm not going to entertain it, and so on. The question is, has Parliament intended that you're even entitled to make that argument, which would amount to a collateral attack on findings that the judge has made? Now, in my submission, the answer to that is plain, that you shouldn't be entitled to use a costs appeal to attack issues which have arisen in the course of a judgment, which you can't appeal because the outcome of the judgment, the decision is final where the judge hasn't given permission to appeal. But potentially you could find yourself in the Court of Appeal, where the Court of Appeal is being asked to make determinations on matters which are in the judgment, but because they go to the question of costs, because what you're being told is costs are being dealt with under the Supreme Court Act and the rules of court, and so everything that the judge has looked at there must, on this argument, be open for play. Now, the reason this matters is, I mean, there's a separate point about delay and expense, but the collateral attack point matters because part of what is going on in the statute and the cases is that one is concerned with finality with all of this. And so there's finality in terms of not having delay and expense, but also finality that you've had an arbitration award. Now the court, you've had one shot to look at it. The court could have decided, yes, I'm going to uphold the award, or it's decided to set it aside. Now what you shouldn't have then is other court proceedings here, an argument, I mean, not in this case, but theoretically, an argument in relation to costs, which actually is a collateral attack and undermines the finality of the award. So take my example. If you had a situation where a party in P&ID's position came along to this court and said, this was unfair, and I'll explain to you actually how it did arise in this case actually in a moment, came along to this court and said, this is unfair, and the court said, well, yes, we agree a fair opportunity hasn't been given to the witness to deal with this. So I'm going to say that the basis of a finding of dishonesty was inappropriate. Therefore, I'm now going to say the costs order was inappropriate. You've undermined the process of finality of the award in that at least, although the decision is final, you have out in the, as it were, in the marketplace, the Court of Appeal casting doubt on the validity of the judgment. And this did actually arise in this very case, in this way. Mr. Andrew, the solicitor, who was a director of P&ID, the judge was made critical of him, found he'd acted dishonestly, and he then independently sought to appeal to this court, rather like in my Lord will remember the Bayo case, where the solicitor who you'd found had been dishonest tried to say his human rights had been unfairly dealt with. That's exactly what Mr. Andrew tried to do. Now, he didn't get permission because of things to do with the way he'd acted and so on. But, and one of the grounds was, in fact, also it would be potentially a collateral attack. But one can see in this type of situation where it could have been P&ID coming along and adopting these arguments, saying this is all very unfair to our witnesses, that if the points weren't put clearly enough to them, or whatever it was that was being said. And so I do say that it would be inconsistent with the whole spirit of the Arbitration Act and what Section 68(4) is intended to do if that sort of collateral attack could be made. Now, my learned friend says, well, you don't need to worry about that because this is just concerned with a point that could apply in any case, which is the currency of costs. But in my submission, one has got to look up from, as my Lord the Chancellor was saying, from this particular case and see the ramifications. And in my submission, once one understands that, that explains the policy that one sees in the other cases that one actually takes a broad approach to what is meant by a decision under Section 68.
But you still need to get permission to appeal in any given case. But your point is that if Mr. Malone were right, then it would be possible to apply for permission to appeal to the Court of Appeal in any case in relation to the costs award the judge in the commercial court.
Yes, that's right, and it would be on any grounds, which will have to be obviously grounds that the Court of Appeal would consider rendered the judgment incorrect, but on Mr. Milner's argument, on P&ID's argument, it's open, it is entirely open. Any points that are available, you can run on a costs appeal, and the Court of Appeal, even though the trial judges refused permission, can then grant permission. In my submission, see the time, that is inconsistent with the spirit and policy of the Act, and indeed the broad approach that this court has taken to the interpretation of Section 68.
That does involve taking a rather broader approach to what's meant by under this section, doesn't it?
It does. Well, it's the approach that the Master of the Rolls, when you were sitting with him, thought was correct, but obviously that was in the course of an oral exchange, but none the worse for that, bearing in mind the source. But one can say there isn't any case other than the Manchester case where you discussed it in the course of argument with Lord Panic, but the other cases are concerned with a slightly different situation, but the issue for you is how do we then apply that to the costs regime?
Is that a convenient moment, Mr. Howard?
Yes, sir.
Okay, 2 o'clock.
What rank of fable?